Hello to all, and thank you for joining us for the first video of our project designed to introduce the model laws developed by the United Nations Commission on International Trade Law, or UNCITRAL, in the area of cross-border insolvency law. My name is Olya Antle, and I'm joined today by my colleague, Shuai Guo.
Hello, everyone. This first video is devoted to the UNCITRAL model law on cross-border insolvency, which was first issued by the Secretariat of UNCITRAL in May of 1997. This year, we marked the 27th anniversary of the adoption by UNCITRAL of this model law, and are taking this timely opportunity to celebrate a significant contribution to the development of cross-border insolvency law.
That's right, Shuai. Through this video, you will learn about UNCITRAL, the purpose and structure of the UNCITRAL model law on cross-border insolvency, as well as the tools this model law provides to promote efficient administration of cross-border insolvencies. Throughout the video, we will abbreviate the model law on cross-border insolvency to MLCBI.
Earlier, the model law was drafted by UNCITRAL Working Group 5. Can you tell us what is UNCITRAL and how it is structured?
Absolutely. UNCITRAL is organized at 3 levels, one of which is the working groups that undertake the development of the topics of UNCITRAL's program. Working Group 5 focuses its work on cross-border insolvency law and has thus far drafted 3 model laws, including MLCBI.
Speaking of model laws, I think it is important to mention that a model law is a suggested template for lawmakers to consider when adopting it as part of their domestic legislation and transposing it into national law. States that enact a model law into their legal systems have the flexibility to depart from proposed text. This way, each jurisdiction can transpose a model law with specific variations to fit its existing insolvency regime. And so when we think of jurisdictions that have adopted the MLCBI, legislation of each should be considered to identify any deviations from the model text.
That's right, Shuai. And as of the creation of this video, legislation based on or influenced by MLCBI has been adopted in 59 states and 62 jurisdictions. The first states to enact MLCBI were Mexico, South Africa, and Japan in 2000. And the last state to enact MLCBI, at least thus far, was Saudi Arabia in 2022. Shuai, let's discuss the purpose of MLCBI and its scope and structure.
Agreed. Let us first start with the purpose. MLCBI was designed to equip the states and their insolvency laws with a modern legal framework to more effectively address cross-border insolvency proceedings concerning debtors that experience severe financial distress or insolvency. The purpose of MLCBI is to provide a simplified procedural framework for recognition of qualifying foreign insolvency proceedings in situations where a debtor has assets or debts in more than one state. MLCBI is structured in 5 chapters and consists of 32 articles. It does not address substantive domestic insolvency law. It only provides procedural mechanisms to facilitate more efficient disposition of cases. The text of MLCBI focuses on 4 key elements or principles. 1, the access principle. 2, the recognition principle. 3, the relief principle. And 4, the cooperation coordination principle.
That it may be best to explain these concepts through a short hypothetical. Let us now immerse ourselves into a hypothetical case that encapsulates the intricacies of cross-border insolvency. Within this scenario, we encounter Company X, a business entity officially registered in jurisdiction A, while also having its stocks publicly listed in jurisdiction B. However, the core of its commercial activities and operations is anchored firmly within the territory of jurisdiction C. For the purpose of financing, Company X has ventured into the international realm by issuing bonds governed by the law of jurisdiction D. This move allows the company to access capital from a broader international investor base. Concurrently, Company X extends its footprint by holding significant assets in jurisdiction E, signifying its multifaceted global presence. The focal point in the domain of international insolvency law lies in the pivotal question of which jurisdiction possesses the competency and authority to initiate insolvency proceedings. The matter is complex, often involving various parties, regulatory bodies, and legal frameworks, each within its own interests and priorities. When an insolvency proceeding is indeed set into motion in any of the aforementioned jurisdictions, a critical concern arises. Will this proceeding be recognized in other international jurisdictions? Should recognition be granted, the next question relates to the type and extent of relief that may be made available. The nature and scope of such relief can vary significantly depending on the specific legal systems. For example, relief can be interim or urgent, relief could be automatic, or relief could be discretionary. Relief may focus on protecting the assets of the debtor or the interests of the creditors.
Yes, and model law is designed to address these issues effectively and efficiently, promoting coherence and coordination across jurisdictions. As we previously mentioned, through its 5 chapters and 32 articles, MLCBI is meant to 1. Establish procedures to allow insolvency representative of company X, aka the foreign representative, to access courts in other jurisdictions where company X has assets, as well as allow for access to proceedings by the creditors of company X. This is often essential for the effective protection of the debtor's assets. 2. MLCBI is also meant to provide a process under which the court receiving the foreign representative's application may recognize the other insolvency proceedings. The object of such recognition is to avoid lengthy and time-consuming processes and to enable the receiving court, once such recognition is granted, to determine what kind of relief is appropriate. Recognition may be given on 2 grounds. 1. A foreign proceeding is taking place in a state where the debtor has its center and main interest, COMI. Or 2. A foreign proceeding is taking place in a state where the debtor has establishment, meaning a place of operations where such a debtor carries out uncertain non-transitory economic activity. 3. MLCBI also provides a path for such a receiving court to grant relief, including urgent relief to protect and preserve the value of debtors' assets, should such relief be necessary. And 4. Finally, MLCBI places obligations on all courts involved to communicate and cooperate to the maximum extent possible. Because recognition in insolvency proceedings across borders is a challenging endeavor, the need for a harmonized and robust legal framework to facilitate cross-border insolvency matters, such as the MCBI, is crucial.
Thank you, Shuai. This concludes our first segment on the purpose and structure of MLCBI. Stay tuned for other videos, which will go into greater detail with regard to MLCBI's implementation. Until then, goodbye, and thank you for listening.